Mr. Hofmeyr, are you ready for us? Mr. Arons is ready for us.
I am, thank you.
Thank you, Madam Chair. Thank you, Madam Chair. Good morning to the honourable panelists and Mr. Hofmeyr and my colleagues and everyone in the room. Good morning, Mr. Hofmeyr.
Good morning.
Morning. You've had the opportunity to consider and read and take counsel in relation to the judgment I referred you to the last time. Is that right?
That's correct.
Okay. So I take it you've got a copy of it open in front of you? You have?
I do, thank you.
Thank you. I will then just refer to the, Madam Chair, with your leave, I'll just refer to the relevant paragraphs in the judgment as I go along for this part of my cross-examination. You'll see, Mr. Hofmeyr, at paragraph 10 of the judgment, it is recorded that you were the principal deponent on behalf of the NPA. Is that right?
That's correct.
And you were also part of the team, part of the prosecution team that considered representations made on behalf of former President Zuma. Is that right?
That's correct. You'll also see at paragraph 17 that the judgment records that the actual prosecuting team, led by Advocate Billy Downer, had a view that the evidence on which the charges were based was untainted and that the prosecution should continue against the former president. And that this view was supported by eminent outside senior counsel. You see that at paragraph 17? That's correct.
Do we still have Mr. Arons online? Looks like we're stuck. Okay.
Differed from Mr. Downer and his prosecution team as regards the decision to prosecute the president.
We had lost you for a while, Mr. Arons. There was no transmission of your voice for a while. So you might want to start whatever you were saying, the question from the beginning, after Mr. Hofmeyr had responded, the last time he responded. Can you just start from there?
Sorry, Madam Chair, can you hear me now?
After the question of the untainted evidence. Okay. After Mr. Hofmeyr,
can you hear me now?
Yeah, we had lost you. We couldn't hear you. You can speak now, Mr. Arunsa. Just repeat your
Thank
question.
you, Madam Chair.
Or your statement.
Mr. Hofmeyr, just arising from the judgment, it appears that the prosecution team under Mr. Billy Downer maintained their view that there were strong prospects of a successful prosecution against the former president, but that you and Mr. Mshe differed from that view. Is that correct?
It is correct, but I think in the end, all my colleagues that were on, or almost all my colleagues that sat on the committee did share my view and that of Mr. Mshe.
But your view and some other members of your committee may have shared that view, but the actual prosecution team led by Mr. Downer felt very strongly that the prosecution should continue.
That's correct. I think I've said so already.
Now, you'll also see at paragraph 22 of the judgment that Mr. Downer and his prosecution team had sent you a memorandum, but that you, in particular, not Mr. Mshe, responded to the memorandum and suggested that the prosecution's team memorandum be amended to emphasize Mr. McCarthy's role in the decision to formally institute proceedings against Mr. Zuma. Is that right?
That's correct.
Mr. Hofmeyr, did you hear that?
I did. I responded that it is correct.
Okay, sorry, I didn't catch that. Now, just to pause there, why did you do that? What business have you got to interfere and seek to influence a memorandum written by the prosecution team that has been working on this matter for many years?
I made the proposal because factually the person or persons in the DSO who can make the decision was Mr. McCarthy and Mr. Ngwengwe. McCarthy is the head of the Scorpions and Ngwengwe is the sort of investigating director of the Scorpions.
So were you standing in for Mr. Ngwengwe and Mr. McCarthy, who are now no longer present?
I think my suggestion was just that it should be factually correct, the memorandum.
But if it's just a question of correcting the factual situation, why did the prosecution team refuse to make the changes suggested by you?
It's a slightly complicated answer. The issue was that through most of the Zuma prosecution, the national directors have said that they took the decision. Now, as I said in my submission to the Commission, the national director has no power to institute a prosecution. What they meant, I think, as I say in my submission as well, is that they had been consulted, they'd been briefed on a decision, but I did not think it is factually correct to go to court and talk about a decision by, for example, Mshe, when he does not have the power to make it, but when the reality is that he was consulted, he was briefed, he'd agreed with the prosecution to go ahead, but that does not make it his decision. So I wanted us to be accurate in the way that the memorandum was drafted.
But Mr. Hofmeyr, it is quite apparent from the judgment which you have now studied again since it was delivered in October 2017, that it was not just a matter of nuances and semantics. You and Mr. Mshe, in fact, did not agree with the prosecution team. Your view was that the prosecution of the former president should not proceed, and mainly because of what you regard as a factual inaccuracy in the prosecuting team memo, i.e. the telephone conversations involving Mr. McCarthy. Isn't that so?
Sorry, Chair, I don't quite understand the question about the factual inaccuracy part.
Earlier, we went through your attempt or your suggestion to change the memo from the prosecutors. And you say it was because you wanted to be factually accurate, i.e. to record the telephone conversations involving McCarthy. We went through that. Now you went on to talk about the fact that the NDPP doesn't have the power to prosecute, and you also suggest that Mr. Mshe had gone along with the decision to prosecute the former state president. Now I'm putting it to you that your and Mr. Mshe's position was fundamentally opposed to the prosecution's team position that the prosecution should go ahead.
I'm a little bit unclear. You just said that Mr. Mshe supported the prosecution. Maybe I didn't hear you correctly.
I think the proposition is that you and Mr. Mshe did not.
I understand that part of the question, but I'm just unclear about the previous statement that Mr. Mshe had approved the prosecution, unless I misheard.
No, that's not what he said. Mr. Arendse is attempting to impress upon you the fact that you and Mr. Mshe on the one side and the prosecution team on the other side differed with regard to whether to proceed with the prosecution. That's what he's trying to impress upon you.
Sorry, I can't hear that at all. Sorry, Madam Chair.
No, I'm trying to let Mr. Hofmeyr know that what you are saying is that the prosecution team on the one side and he and Mr. Mshe on the other side differed with regard to whether the prosecution should proceed or not. And he and Mr. Mshe agreed that the prosecution should not proceed, whereas the prosecution team itself had the view that it should proceed. Now, did you hear me, Mr. Arendse? Did you hear that?
Mr. Arendse, did you hear the chair?
But do you understand the question, Mr. Hofmeyr? Yeah. That's what he was trying to say to you. Mr. Arendse, are you with us?
Madam Chair, let us try from this side. Advocate Arendse, can you hear us? Mr. Hofmeyr, will you try from your side? It's sometimes better that side.
Mr. Arendse, can you hear us?
Madam Chair.
Madam Chair, I'm afraid it's a poor connection. I can't hear. I haven't heard anything Mr. Hofmeyr has said.
I think we may be having trouble on the sound on that side, so I'll quickly troubleshoot that.
We're trying to correct the sound
Mr. Arendse, can you hear me?
situation here.
Hello? I can hear you, yeah? Yeah.
Can you hear us, Mr. Arendse?
Yes, Madam Chair, I can hear you now
Oh,
clearly.
that's good.
But
That's
I
great.
think from time to time, it's the connection has been poor.
Yeah, we apologize. You know, sometimes with technology, things just get out of hand.
Yeah, I didn't hear Mr. Hofmeyr's last response to what I put to him. It wasn't really a question. What I put to him,
Yeah.
and he was responding to it.
Yes. I think he said that was correct. Is it correct, Mr. Hofmeyr?
If we're talking about the people who constituted the review in the NPA, it was not quite correct. So the people who constituted the review was the acting NDPP, which was Mr. Mshe, myself, Advocate Sibongile Mzanyati, who was at that time the sort of taking responsibility for the DSO after Mr. McCarthy had left. And then Mr. Ngwengwe, who was the investigating director, did form part of some of the meetings as well, not all the meetings, if I remember correctly.
So Mr. Hoff, can you hear me?
I can hear you.
Okay, thank you. So what were you reviewing? Were you reviewing a decision taken by someone, and if so, who took that decision? Or were you reviewing the decision of the prosecution team to institute the prosecution? What exactly were you reviewing? And in terms of what power under the NPA Act?
Chair, the decision was being reviewed in terms of the power of the NDPP to review a prosecution decision as provided for in the Act. So while the NDPP doesn't have original decision-making powers, you remember that the Act provides that he can be approached to review a decision that has been taken.
So is that the 22C section?
I don't have the Act in front of me, but
Yeah,
it's that section, I believe.
I think it's the same section. Yeah, section that. But who submitted this decision to the NDPP for review?
Mr. Zuma made representations to the NDPP asking for the review.
And against whose decision?
So the whose decision is not an uncomplicated question. Because some of the previous NDPPs had purported to make the decision. But essentially what he was reviewing, I think at that stage, after the search warrant judgment and so on, was a decision by Mr. Ngwengwe, if I recall correctly, who was the investigating director of the DSO, the deputy head of the DSO, essentially.
But we know that originally, former NDPP Nuka took a decision not to prosecute the president. You recall that decision? You were party to that decision.
Sorry, you may have to refresh my mind. Are you talking about the original prima facie decision, that there wasn't a prima facie case?
Yes.
No, I was not part
Yes.
of that decision. I was excluded from the deliberations.
But you were at the NPA at the time.
I was, but I believe I shouldn't have been excluded, but I was excluded from the decision.
And that decision too, if I recall, Mr. Nuka said was based on legal advice of senior counsel.
Yeah, I don't have personal knowledge of that, but I think he did say that.
Yeah, and I know we went quite a few things you don't have personal knowledge of, but because of your institutional memory and because of your involvement at the NPA, you have offered to comment on a range of issues. And I would have thought that this is an issue that would stand out in your memory.
It is an issue that stands out because I was excluded from the decision and I would not have agreed with the decision at the time, but I did not play any role in that decision.
So, who did you say subsequently took a further decision or another decision to actually institute the prosecution?
My understanding is, sorry, I have not gone through all those timelines, but my memory is that the KZN High Court set aside the search warrants in the Zuma matter in about 2006, 2007. We took that decision on appeal to the Supreme Court of Appeal and won the decision. So that had the effect that the prosecution could be, could continue or be reinstituted.
But why do you, or can you explain why it, and of course I confine myself to the judgment, why at paragraph 22, where it's recorded that you responded to the memorandum of the prosecution, suggesting to them that the memorandum be amended to emphasize Mr. McCarthy's central role in the decision to formally institute proceedings against Mr. Zuma. And I want to quote to you, and it's in the judgment, the relevant part of the email reads as follows: at our meeting on 29 November, it was decided that the head of the DSO should take the decision. The subsequent discussion with McCarthy and you was that charges should, after 1 January, that should be after 1 January. He says McCarthy phoned him about the 21st or 24th to say he wants to proceed now. He then informed him that he does not agree and that it should wait until after 1 January as previously agreed. But he said that since it was the head of the DSO that must take the decision, it was up to McCarthy to make the decision. In a further email, Mr. Hofmeyr said, amongst others, clearly McCarthy made the decision to institute the prosecution proceedings between Christmas and New Year without the support of the NDPP, but pretended that he had the support. As far as one can see, Tanda Mgwengwe was not involved in that decision. He was simply asked to sign. That's what you wrote in your email to the prosecution team.
So, Chair, I think the context of the email was about the debate that takes place in the spy tapes at that time, whether it would be more advantageous for Mr. Mbeki's chances to be re-elected if Mr. Zuma was charged before the Polokwane conference or after the Polokwane conference. So I think that's why it was important to try and determine when and who exactly made the decision at the time.
Important for who?
It was important for the 5 of us who were doing the review.
Are you saying, suggesting, or is it your view that it was only a question of timing for when the prosecution should be instituted and not the actual decision to prosecute itself?
I think what concerned us was the sort of political motivation for when the prosecution should be instituted. So there's a debate between Mr. McCarthy, Mr. Ngcuka, and some others about when this prosecution should be instituted to have the maximum benefit to Mr. Mbeki.
Now, do you accept that as a matter of law, as a matter of policy, NPA policy, and as a matter of constitutionality, that such decisions that you ascribe to Mr. Ngcuka and Mr. McCarthy, that those are unacceptable and that it constitutes an interference with the independence of the NPA?
Chair, I will concede that after the experience in the Celebi case, where we had seen significant political interference in the work of the NPA, supported by the persons involved in this inquiry, that I think that I overreacted on this issue of political interference. I do accept the subsequent SCA judgment where it is said that motivation doesn't matter as a matter of law, but I do think that some of the later cases that I raised, those issues again very much raised the question of political motivation for certain charges. But I accept, Mr. Arendse, that I was incorrect in my feelings at the time and that I did overreact. But I do want to make the point which you've not made, is this was not a decision only by Mr. Mshe and myself. The people doing the review all agreed with the decision. It was not a decision only by the 2 of us.
Mr. Hofmeyr, just 2 things. Do you accept that whether it was your decision only or mainly, or whether it was made as a team, that decision too constituted political interference in the decision-making process of whether or not to prosecute, or whether even to prosecute only at a particular time?
Sorry, I'm not quite understanding. If you could just repeat the question. I didn't quite understand how the particular time fitted into the rest of the question.
I put it to you that the decision that you supported, whether on your own mainly or solely, or together with Mr. Mshe and some of the other directors, i.e. the decision not to prosecute the former president, that decision too amounted to political interference in the decision-making processes of the NDPA.
Mr. Arendse, I don't quite understand by whom that political interference was, or what you suggest was the political interference. It was a decision by the top management in the NPA at the time. We, as far as I know, we did not consult with any politicians about that matter. Perhaps you have evidence to the contrary, but it was the view that we as the prosecution team as the top management of the NPA came to.
Mr. Hofmeyr, aside from exactly the point that you make is the issue of political interference, where does that come from, and where you accuse Ms. Jiba of meddling in politics. There is no evidence to that effect before this inquiry, but we'll come to that a little later. What I am putting to you is not to mention any politicians or that they would have influenced you, but you yourself took a political decision not to institute the prosecution when you supported Mr. Mshe's decision to discontinue the prosecution. There can be no other rational explanation for that decision.
I disagree, as I said earlier. For me, the issue was about the integrity of the NPA and whether it was making politically motivated decisions. And as I said earlier, I don't think the courts agreed with us, and I accept the court findings. But our decision was based on the evidence that there was before us that there had been political meddling in the making of the decision.
Mr. Hofmeyr, I think you can't have it both ways. You can't accept the decision of the Supreme Court of Appeal and then seek to somehow qualify it or somehow deviate from it. Because what is very clear from the judgment is that Mr. Downer and his prosecution team were adamant that on the merits of the charges brought against the former president, they had no doubt in their mind that there were good prospects in a subsequent criminal trial. That is purely on the charges. The issue of meddling that you allege on the part of Mr. Nuka, Mr. McCarthy, and former President Mbeki, that the court said had nothing to do with the merits of the criminal charges against the former president. Do you accept that?
I do accept that, as I've said repeatedly, but there had not been a decision by the court on that issue up to that time, on this particular issue.
But there was a decision previously by Judge Nicholson in Pietermaritzburg. You remember that decision?
I do remember it.
That was a stay decision on his part, and that decision was subsequently attacked in quite a scathing manner in the SCA and was set aside. And that too was based on alleged interference in the in fact, the role of Mr. McCarthy and Mr. Nuka with the telephone conversations. Do you recall that decision?
I recall the Nicholson decision, and I think at that time I was actually asked by the NDPP to join the team that was doing the Zuma case, because our counsel in the Pietermaritzburg judgment, if I recall correctly, had essentially suggested that the case should be abandoned, that we did not have good prospects on appeal. So I had a discussion with the NDPP at the time. We decided to bring in the new set of counsel that was involved now in the period we're talking about, Mr. Trengrove, led by Mr. Trengrove. So I was involved in helping to rescue the case when actually the bulk of the people were ready to give up that case.
So just while you mention new counsel, other counsel, previous counsel, you accept that in the NPA you are guided from time to time by the views and opinions of outside senior counsel in particular. And sometimes that view is a correct view or a sound view, and sometimes it's not. Do you accept that as a general proposition?
In a qualified way, I think when you get the views from counsel, you still have to, you cannot absolve yourself from the responsibility of the decision that is taken.
So, for example, in the spy tapes case, you can't absolve yourself from the decision that you and Mr. Mshe took not to continue with the prosecution in the face of strong prosecutorial resistance to such a decision.
Maybe I should just repeat that it wasn't just a decision by Mr. Mshe and myself. I mean, legally it was a decision by Mr. Mshe, but we had 5 people sitting in the review process, and whatever Mr. Mshe came to in the end, it was those 5 people who, or the other 4 people who agreed with him on the dropping of the charges.
Now, again, the judgment criticizes your absolutely central role in that decision-making process, not of Mr. Mshe or of the others. Do you accept that?
I accept it in the sense that I was asked to depose to the affidavit, so the things that I said there is in my name, although I did make it clear that it was not my view on its own.
Now, you speak about, I think you mentioned earlier, and you can correct me if I misstate your position, that when I put it to you that the decision the decision to discontinue the prosecution of the former president on the basis of Mr. McCarthy's alleged manipulation of the process, that had nothing to do with the merits of the charges against the former president. You recall that?
I think I have already agreed that I acknowledge that we were wrong in taking that into consideration.
So do you also accept then we didn't quite agree on the issue of the advice of outside senior counsel from time to time? I think you correctly say that at the end of the day, that as the prosecutor concerned or as the senior person concerned, you must accept ultimate responsibility. But in relation to the decision in spy tapes, you accept that you actually got it very badly wrong. Now, do you accept that even senior NPA officials like yourself and Mr. Mshe sometimes do get it badly wrong? And that's why the courts play an important role.
I accept that, but I think after the judgment was delivered in this case, there was no more grounds for getting it wrong in future.
So when a prosecutor or a senior prosecutor or a senior person in the NPA, even an NDPP or an acting NDPP, when they get it badly wrong from time to time, does that manifest that they're not fit and proper to serve in that position? Or I suppose, are you going to say it depends on the circumstances and the facts of each case?
I do think it depends to a significant degree on the circumstances of the case. But I also think that there is a difference between a decision like that to not prosecute and a decision to prosecute somebody where there is very little evidence, which is a phenomenon that we saw later.
Now, the same side of the coin, you must agree, is that where there is overwhelming, or let me rephrase that, where certainly, because obviously the merits of the charges against the president may or may still be debated in our courts, but where the prosecutors themselves were implacably opposed to any decision to discontinue the prosecution, and you and Mr. Mshe and your team nevertheless saw fit to do so. Surely that is not only an error of judgment, but poor judgment.
As I've said before, I think there was little case law before us at that time dealing with this issue. But after this, there was case law dealing with the issue. But I also think there is a difference between a case where there's evidence and the matter is withdrawn, and the cases, as we saw later, where people are taken to court and the courts find that there is no evidence before the court to justify a prosecution. I think there's a very big difference between those scenarios.
Let's deal with your scenario, Mr. Hofmeyr. I want to put it to you that you and Mr. Mshe in particular, that you played politics in this decision not to continue with the prosecution of the former president, because you made a political judgment in respect of these telephone recordings of calls between Mr. McCarthy and Mr. Nuka.
I reject that it was a political judgment. As I've indicated before, in my capacity as head of asset forfeiture, we had been involved in seizing the assets of Mr. Sheikh initially. After the search warrant case throughout the Zuma prosecution, I was pretty instrumental in actually ensuring that the prosecution gets back on track. And yeah, so I do not think that I took into consideration political considerations. What concerned me here was the way in which people in the NPA had behaved unethically in relation to this prosecution. As I've said before, I concede that I overreacted, and I probably overreacted because it was in the wake of the Celebi issue case where people playing political games in the NPA had become a very serious issue in the NPA.
Mr. Hofmeyr, would you accept that if you are right or were right in your view that both Mr. McCarthy and Mr. Nuka decided not to proceed with the prosecution, or rather in their telephone conversations that they were abusing the prosecution process and thereby bringing the NPA into disrepute? Would that be a fair summary of your thoughts about what they did?
I think so, but it obviously has to go together, I mean, with the initial decision to not prosecute, because although there was a prima facie case, there was not a winnable case, I think it was called at the time.
Now you used pretty strong language in your affidavit in that case, and you referred to, and I quote, manipulation of the prosecution process for ulterior purposes. You remember you made that statement?
I can't remember the exact words, but I did say something like that.
Yes. Now, if that is in fact the case, surely Mr. Nuka and Mr. McCarthy, they are not fit and proper to serve in the NPA, if you are correct about that. Surely that must be the worst form of bringing the NPA into disrepute.
Well, perhaps it was not a coincidence that Mr. McCarthy sought to be employed in a job overseas before these facts came into the public domain. But the allegations had already been made before then.
But Mr. Nuka is still in our country, and you make serious allegations against him. If they're not true, then they must be defamatory.
I would be... I mean, Mr. Nuka has given no indication that he would like to take this matter to court to be adjudicated upon.
Well, he might well, but here we're sitting with a past, in fact, the first National Director of Public Prosecutions, and you, in your evidence earlier in chief, had said that one of the, for you, a golden period of the NPA was under Mr. Nuka. Isn't that so?
I said that the initial period under Mr. Ngcuka was a golden period. I think our proper golden period was under Mr. Pikoli, who was removed for being too honest, to be blunt.
And isn't it ironic that Mr. Pikoli had absolutely no experience as a prosecutor prior to being appointed as the NDPP?
I think that's true of a number of NDPPs who have been appointed. And I don't want to speculate about the reasons for that, but the reality is that most NDPPs who were appointed had not had prosecution experience before.
Yes, I think I pointed that out to you, Mr. Hofmeyr. In fact, none of them. The only two, the acting NDPP is my client, Ms. Jiba, and subsequently Mr. Abrams, whose appointment was set aside as unlawful.
That's correct.
Now, just to return to what we were discussing, Mr. Hofmeyr, at paragraph 33, the court records as follows. Mr. Hofmeyr was the most vociferous of those within the NPA management in advancing the argument that the prosecution should be discontinued, and, as referred to above, was the principal deponent in opposing the DA's application. The case sought to be made by him was that it was Mr. McCarthy that had influenced Mr. Mshe in respect of the timing of the service of the indictment. The timing of the service of the indictment was in relation to the African National Congress National Elective Conference to be held from 16 to 20 December 2007 at Polokwane. You recall that statement?
I do.
Yes. And of course, we know that Mr. Zuma was a candidate to be elected as president of the ANC at that conference, and ultimately the president of the country.
Indeed.
Now, according to you, the telephone conversations that Mr. McCarthy and his co-conspirators in favor of former President Mbeki and against Mr. Zuma, their purpose was to avoid Mr. Zuma being elected. Is that right?
I would put it more positively. I think that their purpose was to ensure that Mr. Mbeki was re-elected.
You're right. In fact, you submitted, you contended, you alleged in your affidavit that they acted in collusion with former President Mbeki. Is that right?
Yes.
Now, you will also see in the judgment that that counsel acting for the NPA in the matter, I think it was Mr. Epstein, assisted by Ms. Platt and PB Khoza, that they wanted it placed on record that none of them had a hand in drafting and finalizing the affidavits, your affidavit on behalf of the NPA. You recall that?
I do.
Is that not extraordinary for counsel to disavow any hand or any reliance on an affidavit of a client? Or maybe you can
I'm
explain.
not sure that
why
they
you think
were
about
counsel at the time that the affidavit was being drafted.
So can you recall who counsel was?
Can we, Mr. Arendse, we are requested by the recorders to take a break.
I'd appreciate that, Madam Chair.
Yes. Motivated
I'm
by
sure
you.
Mr. Hofmeyr too.
Yes. No. Yeah. So I think
Shall we
this is an
resume at,
opportune time.
I have no objections.
In 15 minutes, Madam Chair?
Yeah. I think 15 minutes would be fine. We can come back
Thank
at
you.
11:30, okay? Thank you. Later.
Thank you.
We adjourn until 11:30. Thank you.
facts from which he or this court could draw such damning conclusions against any of the individuals concerned. I mentioned Mr. Mbeki, Mr. Kessel's, Mr. Nuka, and Mr. McCarthy. He speaks of investigations, the ambit and nature of which are not disclosed. He refers to rumors and tells us what he believes. He makes statements such as far as I'm concerned, this is a wholly unsatisfactory approach. The court did not, you are suggesting that somehow what you said is justified, but the court said, well, it might be justified, but it's not relevant. That's not what the court said. Do you agree with me?
Sorry, I'm not sure I understand the question.
No, it's not the question. I was reading back to you what the court said. You said the court found that what you said in your affidavit was not relevant to the decision. I just read back to you at paragraph 73. Far from saying that it wasn't relevant, the court says that your approach was, to quote them, wholly unsatisfactory because you did not provide any facts. Your allegations were based on rumors. You spoke about your investigations, the ambit and nature of which you never disclosed. So the court was rejected completely your evidence in your affidavit.
I'm not sure that I agree with that, but if the inquiry will indulge me, I'd like to go through those one by one and see which it rejects. But I do want to make the point that we were not operating on the basis of zero evidence. We had listened to the so-called spy tapes in a great deal of detail. We had transcribed them. And most of the issues I raise in regard to McCarthy and Nuka is based on extensive conversations between them on the telephone. It's not been disputed that those are falsified or not proper recordings of the interceptions. We took a great deal to make sure, as much as we could, that they were indeed proper recordings and that there was proper authorization for those recordings to be made. But what I say about those issues is mostly based on what is said on the recordings, plus some of my personal knowledge of the cases that was being discussed by them.
But Mr. Hofmeyr, what did or do those recordings have to do with the charges? Well, what is it now? Maybe you can help us. Is it 783 charges? Something like that? What has it got to do with the merits of the charges on which Mr. Downer and his prosecution team based their decision that the prosecution should proceed? It had nothing to do with it.
Chair, I think I have answered that question in detail already. That I gave...
You see...
Sorry, if I can finish my answer?
Of course, of course. Sorry.
I have dealt, I think, previously in some detail with the issue about the facts in the case and whether there was a justified criminal charge. I agree that there was. What I had also said is that I gave undue, and it was not only me, it was my colleagues as well, we did give undue importance, perhaps, to what was being said on the recordings, where it was clear that there's attempts to manipulate this case for political reasons. yeah. It's not that the recordings did not provide any evidence. There's a huge amount of evidence in the recordings. Whether they may be admissible in a criminal case or otherwise is a different issue.
In fact, Mr. Hofmeyr, the court went on to say that you were intent on imputing the decision to prosecute Mr. Zuma to Mr. McCarthy. You sought to dispel, and I'm reading from paragraph 75, he sought to dispel as untrue the statement made on behalf of the NPA in an affidavit in other litigation that Mr. Mshe had made the decision to prosecute. This was done notwithstanding that this court in Zuma, in a previous case, had decided on the evidence placed before it that Mr. Mshe had taken the decision to prosecute Mr. Zuma. In his affidavit in the present case, Mr. Hofmeyr claimed that Mr. McCarthy had taken the decision to prosecute almost immediately before turning to assert Mr. Mshe's powers, purportedly in terms of Section 1795D of the Constitution, to review a decision of a DPP. The DPP he was referring to was Mr. McCarthy. One is left with the impression that Mr. Hofmeyr took up this position because he was intent on legitimizing Mr. Mshe's decision to discontinue the prosecution. This, the court said, appears contrived. Now, this too, Mr. Hofmeyr, goes against your earlier evidence. You remember when I asked you about who made the decision, how it came about, what were you and this committee doing? And the court says that your explanation and the position you took appears contrived. That's also trenchant criticism of your conduct, isn't it?
It is criticism, but I tried to reflect what had actually happened. So when this process, the review process started, we had a discussion with the NDPP and the others who were part of it. I think we all agreed that the law does not envisage or frankly permit the NDPP to make prosecution decisions, that he is only allowed to make decisions where a matter is brought on review to him from a DPP or a Deputy National Decisions in the case of the Scorpions. So while Mr. Mshe was briefed on the intention to prosecute, as NDPPs are briefed in most high-profile cases, that does not make him the decision maker in the case, the person who institutes the prosecution. In the Scorpions at the time, there were two people who had the authority to institute prosecutions. The one was Mr. McCarthy as the head of the Scorpions, and the other one was Mr. Ngwengwe, who was the investigating director of the Scorpions, and in most cases, practically, he was the decision maker the person who took prosecution decisions.
Mr. Hofmeyr, we know that you have no prosecutorial experience. You were the head of the asset forfeiture unit for many years, and you've been credited quite rightly in bringing many of the high-profile criminals to book and having their assets forfeited to the state. But having said that, what business have you got to interfere in the prosecution or a decision whether or not to institute or discontinue a prosecution when you have no experience yourself as a prosecutor?
Chair, I won't give out that I am an expert on prosecutions. I obviously have worked on hundreds of cases where we used the evidence that prosecutors had to obtain asset forfeiture orders, so I do have a pretty good idea about what evidence is required, what is needed, because we could not go to court on an asset forfeiture case if there was doubt about whether, or significant doubt, let me put it that way, about whether a conviction would be obtained. So in relation to that, I gained my own knowledge and expertise, but I also relied on people with me who were experts in prosecutions and the detail. As I said earlier, this case or this decision did not revolve around the merits of the case, of the prosecution case. I was satisfied that there was merit in the prosecution case. It was not an issue in dispute. The issues that raised my concern at the time was the level of political interference or collaboration by the NPA with that interference. And that's the issue that I felt strongly about and why I felt it was necessary to take a stand on that issue. As I said earlier, I accept that I was wrong about that.
No,
Can I just, Mr. Aaron, sir? Can I just get some clarity here?
Yes, Madam Chair.
Yeah, for my own sake. Mr. Hofmeyr, did you participate in making those interventions as an individual officer or as part of what you earlier mentioned as the review committee?
I made it as part of a formal process set up by the NDPP to review the decision. In that process, he invited the then acting head of the Scorpions. He had the head of the prosecution service as part of it. So he brought in his senior management, plus Ngwengwe was often part of it as well. So
okay, thank you.
I
That's
did
all
not
I needed.
purport to make rulings or decisions or proposal on the strength of the criminal case.
Okay, I needed to understand that. Thank you. You may go ahead, Mr.
May I
Aaron,
continue,
sir?
Madam Chair?
Yeah.
Thank you, ma'am. Mr. Hofmeyr, but I'm not sure whether at the time and still now you had a more experienced prosecutor than Mr. Downer when you were interacting with the prosecution team.
I agree, and I've worked with Mr. Downer very closely over many years, and I think he probably is the best prosecutor in the NPA. But this issue was, sorry, if I can just say,
yeah,
this issue was discussed extensively and at length by the then top management of the NPA, which included very experienced prosecutors such as Mr. Mshe himself, Mr. Ramaite, and others. So I did not, but in any event, I did not dispute the fact that there was a solid criminal case. My decision or my proposal, because it wasn't just my decision, it was a unanimous decision of all of us who participated in that process, was not based on the merits of the criminal case.
Now, Mr. Hofmeyr, you played a leading role in the decision to discontinue the prosecution. Is that not so?
I think me and the other members of the committee all participated at length and in very great detail in this process. So I played my part. I did not think that I was the dominant force. Ultimately, it was Mr. Mshe who had to make this decision. It was, as he does say, it was his decision and his decision alone in the end.
Now, that seems to be at odds with what the court found at paragraph 78 of the judgment. It reads as follows: notes of meetings that Mr. Mshe held with the NPA management, with and without the prosecution team, reveal Mr. Hofmeyr leading the charge to discontinue the prosecution. At a meeting held on 30 March 2009, he was recorded as saying, and I quote, "We will be criticized by those who want us to proceed, but the depth of the corruption was so deep." Earlier during that meeting, Mr. Hofmeyr spoke of quote-unquote ulterior motives and was recorded as being pessimistic about their chances of opposing an application for a permanent stay of prosecution. He also said that manipulation by McCarthy and Mr. Nuka had to be considered and that the timing of the prosecution was important. At paragraph 80, so the court found that you played a leading role in this decision, and at paragraph 80, the court said the following: the picture that emerges from the documents filed in the court below is of an animated Mr. Hofmeyr straining to find justification for the discontinuation of the prosecution. Mr. Hofmeyr discounted the objective facts set out in paragraph 54, namely that the indictment could in any event not be served before the ANC conference because it had only been finalized on 27 December 2007. One is even at this point of time left in the dark about how the service of the indictment after the Polokwane conference would ultimately and conclusively have impacted more severely on Mr. Zuma than if it had been served before the conference. At paragraph 81, I've already set out in some detail parts of Mr. Hofmeyr's affidavit, which are but a small sample of the manner in which he approached the present litigation. He is an experienced litigator who should know better than to present the case in the manner described above. Professionally advancing the cause of the NPA's independence and integrity, he achieved exactly the opposite. One now has a better appreciation of the reluctance of counsel on behalf of the NPA to be associated with the affidavits filed on its behalf. Now, Mr. Hofmeyr, I have not seen criticism as trenchant and as damning as this by the courts in respect of any of the other of your colleagues. This criticism surely must be hard to swallow for you. Because earlier on in your evidence, you said the whole issue of the manipulation of the prosecution process by McCarthy and Nuka and our former President Mbeki, all of that had to do with the integrity and independence of the NPA. Here, the second highest court in the land says you professed to uphold the independence and integrity of the NPA, but you achieved exactly the opposite. You want to comment?
Chair, it's partly difficult for me to comment because when the appeal on this matter was to be argued in the appeal court, I was completely excluded from the process. Submissions were made on my behavior and so on that I was unaware of. I had no opportunity to go to court and put another side of the story. I think it's sort of fairly public record that Mr. Abrams was doing everything in his power to get me out of the NPA at that time. He even offered me other jobs in the criminal justice system to get me out of the NPA. So unfortunately, I have not had access to all the affidavits, the submissions made in the SCA. So it's difficult for me to comment on some of the things that are said in the judgment. I do accept, as I've said earlier and repeatedly, I accept that I made a mistake by attaching so much value to the integrity of the NPA and less value to the actual, or not sufficient weight to the evidence in the criminal case. I will live with that regret for a very long time, but that is what happened. I do know that, at least in some respects, the NPA changed its version in front of the SCA about what actually happened. I'm not in a position to respond to that to give the details of that right now, because I've not had access to all the papers that have been filed. But certainly, Mr. Abrams approached me before the case was argued in the SCA, essentially saying that he wants to argue in the SCA that it was a decision taken by that the prosecution decision was one that was taken by the NPA, by the NDPP himself. I reiterated my position to him at the time that the NDPP does not have such power. Okay, he wanted to argue that because he wanted to say that the NDPP, obviously, if he had made the decision, would be entitled to review his decision without the normal formal processes that are required to do a review. So that part of it I have some personal knowledge of because, as I said, Mr. Abrams talked to me about it. But for the rest, I do not know what the submissions that were made to the SCA. Those were kept hidden from me at the time, even though our division in the NPA was actually supposed to be dealing with that case. It was dealt with by some of my staff who were instructed not to communicate with me about it.
Mr. Hofmeyr, please do not try to deflect from the criticism of the court. This criticism is based not on what Mr. Abrams said. It is not based on what counsel representing the NPA said. It is based on what you said. So why don't you own this criticism and deal with it on that basis? You know, because again, it's part of it seems to be, with respect, part of your nature to come up with conspiracy theories. You again says you don't know what happened. These papers were hidden from you. You know that papers before our courts, especially in the NPA and in the Constitutional Court, is a matter of public record unless one or other or all the parties, with the leave of the court, they can withhold the papers from the public. And you should know that there was and I would have been interested in what was filed at court if I had faced criticism of this nature. Why do you continue to deflect from this criticism? Mr. Abrams is not here to answer
Please
for
give
himself.
him a chance to answer. Mr. Arendse. give him a chance to answer
Yes, ma'am.
each submission that you make. Otherwise, we get lost as to which question he's answering to. You've just made a very telling accusation. I think it's only fair that he answers the question.
Sorry, Chair, if you could just remind me what the first criticism
And therein
was.
lies the
I think-
difficulty. Once a question becomes too long, we get lost, the witness gets lost.
Mr. Arendse, would you kindly repeat your submissions? Or what you put
Ma'am,
into the witness so
thank
that,
you.
in a way
Eh,
that he is able to
yeah.
answer them?
Can I be of assistance, if I may? I
Let's-
think the question really is about deflection. There's a criticism about you made in, I think, paragraph 80 and 81. And the question is, this is trenchant criticism. Your response is titled, trying to run away from that criticism. Why do you blame other people and put up conspiracy theories? Have I summarized it correctly, Mr. Arendse? Boot.
You may proceed.
Yes, Advocate Morocco, I think that's fair. I have put to Mr. Hofmeyr that he should stop deflecting from the criticism by the courts, because the criticism is based not on what Mr. Abrams or the NPA's counsel said. It is based on what he said in his affidavit before the court, and he must take responsibility for it.
Chair, as I have stated earlier, I do take responsibility. I have taken, in the wake of the SCA judgment, I did take legal advice. I was advised that nothing in the SCA judgment constitutes a finding made by the court against me. Despite this repeated criticisms, there is no finding that is made against me. So I accept the criticism. If there were a finding made against me, I would accept that as well. The legal advice I've obtained says there were no findings made against me.
Mr. Hofmeyr, we will debate that at the conclusion of this hearing, because I put it to you that the kind of criticisms of you, directly of your conduct in this case, constitutes misconduct and far outweighs the kind of criticism that has been made of Ms. Jiba in the 4 judgments that's under scrutiny before this panel.
If I may respond to that, my understanding is in a number of those court cases there were findings made. It was not just views expressed in a judgment. And I think that is what differentiated.
Mr. Hofmeyr, I also want to put it to you that it's quite extraordinary that none of some of our watchdogs of our Constitution has ever taken up the criticisms of you in this judgment before any of our disciplinary tribunals, whether in the legal profession, whether the attorney's profession or the advocate's profession.
I'm not quite sure what you would like me to comment on that, but to say that I suspect the reason is that I have some reputation of trying to do the right thing in very hard circumstances. And as I say, I also don't think that there were any findings that people could take to court to litigate against me if they did so wish. And I'm sure there are plenty of people outside there who do so wish to get me out of the NPA.
I hope Mr. Arendse can still hear you, because it seems like your voice is going a bit lower.
Mr. Hofmeyr, I don't want to go into the reasons why some of these bodies haven't taken this matter up. I think I and like-minded people know why, so we're not going to go there. But it's quite significant that this court, the SCA, our second highest court, says that the position you took was contrived, that far from upholding the independence and integrity of the commission, that what you did was to achieve the exact opposite. And how you could say that that is not personal criticism of you, then I don't know what is.
Mr. Arendse, I don't think Mr. Hofmeyr said that is no criticism against him. He actually accepted the criticism. He said he accepts the criticism.
What he said, Madam Chair, with respect, is that he said there were no findings by this court against him.
Yes, that's what he said. He didn't say there were no criticisms and he doesn't agree with the criticisms.
Well,
what he accepted were the criticisms. He said it over and over again. Yes. He said it over and over again.
Let me read further from paragraph 84 of the judgment. It appears to me inimical to the preservation of the integrity of the NPA that a prosecution is discontinued because of a non-discernible negative effect of the timing of the service of an indictment on the integrity of the investigation of the case and the prosecution itself. There is thus no rational connection between Mr. Mshe's decision to discontinue the prosecution on that basis and the preservation of the integrity of the NPA. If anything, the opposite is true. In these circumstances, discontinuing a prosecution in respect of which the merits are good and in respect of which there is heightened public interest because of the breadth and nature of the charges and the person at the center of it holding the highest public office can hardly redound to the NPA's credit or advance the cause of justice or promote the integrity of the NPA. Now, Mr. Hofmeyr, this decision, the court found you were principally involved. You led the charge, as the court put it. So do you accept that that decision that you were party to was an irrational decision?
I think I have already stated my position that I accept the SCA judgment. I just want to add one thing that perhaps is kind of less stressed in the SCA judgment. This was a process to decide who should be the next president of the country. It was not small decisions that were being made. It showed senior officials in the NPA trying to steer a prosecution in a way that would determine who the next president of the country would be. And I think that is pretty explicitly stated in the recordings to which we listened and which have been transcribed.
That is why I put it to you, Mr. Hofmeyr. You were concerned principally, exclusively, with the politics and the political situation in our country, and it had nothing to do with the merits of the charges brought by the prosecuting team. That's why you can say we were now at a crucial historic point in the history of our country. This concerned the election, or the potential election. I mean, we know, of course, that if the ruling party and its majority, that whoever is elected as president of the party would become the president of the country. And you meddled and interfered in that process.
I disagree that I meddled in the process. I felt it was important for the NPA to take action in relation to those who were meddling in the process, who were expressing extremely partisan political views in their conversations that by then had become public knowledge. And I thought it was very important for the I thought it was very important for the NPA to take a firm position on that issue. As I said repeatedly, I accept that it was a wrong decision. But it was, for me, motivated by my abhorrence of attempts to use the NPA as a political tool against those perceived to be opponents of, to put it in shorthand, the president and the people around him.
But the court criticized you for that and said you had achieved exactly the opposite.
Mr. Arendse, that you have asked about 4 times. No, we're not going to. We'll never finish if we go on that way.
In fact, Mr.
They
Hofmeyr,
criticized him. He accepts the criticism on that very basis that you want to ask him about. Please move on.
Thank you, Advocate. Let me move on. Mr. Hofmeyr, and this, I'm afraid, it continues with my theme of Mr. Hofmeyr's political interference in the matter. Why did you exclude the prosecuting team from the process leading up to the decision to discontinue the prosecution? Mr. Hofmeyr?
I did not exclude the prosecuting team from it, and they were not excluded from the process. I mean, it was not my power to exclude them or include them, but I had thought it was very important for us doing the review to engage with the prosecuting team, and that was done in some detail. But ultimately, the power to review is that of the National Director of Public Prosecutions, who was Mr. Mshe at the time. It is his, whoever of us sitting there, whatever arguments we are making, ultimately it is his decision to make. And as I said, at the end, for those of us who were part of the process, there was pretty much consensus. I mean, we agreed. He came into a meeting at the last day and said, this is his view. And
now,
I agreed with the decision, as did all my other colleagues.
Now again, your evidence is at odds with the findings of this court. At paragraph 89, the court said this: the exclusion of the prosecution team from the process leading up to the decision to discontinue the prosecution, especially the final deliberations that took place on 1 April 2009, was in itself irrational. So this is at odds with your evidence. Then the court says the compelling conclusion is that this exclusion was deliberate. The prosecution team's subsequent memorandum protesting their exclusion is understandable. They were senior litigators steeped in the case, acquainted with the legal issues, and had a critically important contribution to make regarding the ultimate decision to terminate the prosecution. They had invested a great deal of time and resources in gathering evidence and building a case that management in the NPA accepted was a strong one. The memorandum pointed out that the views of the 2 outside eminent senior counsel who had been advising the NPA were inexplicably also not solicited. So you did exclude the prosecutors. You tried to change the decision.
Chair, I think that Mr. Mshe, as he is obliged to do, conferred and with the prosecutors, listened to their views, but in the end it is the power to review a prosecution decision vests in the NDPP, not in me as head of the asset forfeiture unit or my colleagues who are in different positions in the NPA. To some degree, probably in Mr. Ngwengwe, who was the investigating director of the DSO at the time. But when a decision is taken on review, it is taken on review to the national director. He can include people in the process if he wants to, but he has no legal obligation to do it, other than to ensure that.
Can I just get further clarification here? What exactly is the role of the review committee and how does it perform that role? It reviews a decision, and how does the process unfold? Does it make a recommendation to the NDPP? And once it has done so, if that is the way the process, if that's what the process entails, how does the NDPP make the decision?
Chair, let me just say, as far as I'm aware, this was the only time that a broader group of people were part of the decision with the NDPP.
So did the NDPP,
it's
so
the
to say,
power
delegate its power to the review committee, or it just gave it a role to assist in reviewing the decision? I want to know what the role of the review committee was and how it
generally
performed the role.
Generally when decisions are reviewed by the NDPP, I think ideally they should take advice. They should engage with the prosecutors, with the DPP in whose name the decision was taken. But there's no requirement that he must assemble a panel or anything like that. Ultimately, the decision vests in the NDPP. He can take advice from people, but he doesn't have to take advice from people.
But that in this case, what happened?
So in this case, he asked essentially the Deputy National Directors to be part of the process. But I think if you look at the proceedings at one stage, he does say it's his decision. He's going to have to be the one that takes the decision and must take the responsibility for it.
Thank you. Thank you, Mr. Arendse.
So, thank you, Madam Chair. So, in summing up, Mr. Hofmeyr, the court said that the case presented by the NPA at paragraph 94, principally through Mr. Hofmeyr, was that Mr. McCarthy's conduct in influencing the timing of the service of the indictment so that it occurred after the ANC's Polokwane conference was so egregious that it amounted to an abuse of process to justify a discontinuation of the prosecution. This, the SCA said, was based largely on conjecture and supposition. The allegations by Mr. Hofmeyr of political machinations on the part of Mr. McCarthy were irrelevant because they were unconnected to the integrity of the investigation of the case against Mr. Zuma and the prosecution itself. The manner in which the affidavits were drawn and the case conducted on behalf of the NPA was inexcusable. And you say those are not criticisms of you. Those are not findings against you.
I think I've dealt with the issues that you raised in the first part of your question already, but I'm happy if you can point out where it hasn't been dealt with. I accept the criticism. I'm not trying to say that it was invalid. What I said is that the court does not come to a point where he said, we find something about Mr. Hofmeyr that renders him unsuitable to be a senior part of the senior management of the NDP, of the NPA.
So Mr. Hofmeyr, this very picture that you have tried to portray to the panel about an NPA being in a state of disarray, the NPA who has lost the trust and confidence of the public, you were party to that. That's what this judgment demonstrates.
I think that the lack of confidence in the NPA, which I think is reflected in the media monitoring services that the NPA subscribes to, has had to do with a lack of action by the NPA in relation to the capture of the state. I think some people still want to say the alleged capture of the state. But the brutal reality is that if I ask Mr. Mokgoro or Mr. Jiba, Ms. Jiba, sorry, I'm tired, which significant corruption case has been done in the last 7 years? I think the answer is zero. Nobody, I've raised this issue in recent NPA EXCO meetings. Nobody knows of any big corruption case that has been done, has been prosecuted where a conviction has been obtained. So when I do want to distinguish what happens under Mr. Ngcuka's auspices from some of the things that happened afterwards, because I think there really was a pretty systematic attempt to ensure that the NPA does not charge senior politicians for corruption or senior officials who are usually the ones involved in the corruption. And it's not because there's a lack of evidence or lack of cases. We've all read about them in the Gupta leaks and elsewhere. There was a list when I was removed from the SIU in 2012 of 80 big corruption cases that had been put together for prosecution by the anti-corruption task team at the time. I've asked recently in the NPA, can we have information on which of those cases have actually been prosecuted in court? And so far, nobody's been able to point me to one of those cases appearing in court. I'm waiting anxiously. I can't preclude the possibility that somebody was given a quick plea bargain and no trial took place, so we didn't read about it in the newspapers. But that is the reality that happened to the NPA in this era of state capture. You capture the NPA because you want to ensure that corruption cases are not done. There may be a few exceptions for people in the ruling party who are perceived to be opponents of the president, like Mr. Pravin Gordhan, who do get prosecuted. I think the court found that there was not a lot of evidence to warrant that. But those are that's the only prosecution I'm aware of for supposedly a corruption-related case. So when we look at the context in which this is happening, I mean, when we look at what is happening here, I do think it's important for this inquiry to bear that in mind and perhaps to get some evidence from outside experts on issues of what corruption is. I think there's a number of NGOs who've written very critical reports on the role of the NPA over the last 8 years. And so I don't think we can explain in many ways, you know, how does somebody suddenly jump 4 levels? I think it's 4 levels, from a deputy director, past the directors, past the deputy nationals, to become an acting NDPP of the NPA in this particular period that we are looking at.
Mr. Hofmeyr, are you finished with your political speech? You know, you've been criticized by the second highest court in the land of being, quite frankly, reckless with the truth, because you make up stories. It is based on conjecture. It is not based on the facts. And now again, in a few minutes, you have sought to disengage yourself from the most trenchant criticism of a senior officials of the NPA in our courts by making a political speech with no factual basis. Now, I'm going to challenge you. You've taken time out on no less than 3 occasions to ask the inquiry for leave to go and read, for leave to go and consult your counsel. So you are in the NPA. Get us the facts and the figures that show that no senior persons who have been accused of corruption have not been prosecuted or have not been prosecuted successfully. As far as I know, or do you know how many authorizations Ms. Jiba issued in her role as the acting NDPP? You wouldn't know, would you?
Not unless she discussed it with us, as had been the practice in the NPA in the past, but it ceased to be the practice.
Yes, you are not a racketeering expert, and you are not involved in that process. I'm going to deal with that later on after lunch. Ms. Jiba has made 27 authorizations under POCA. Many of them have been successfully prosecuted, and some of them are still in the process of being prosecuted. So I'm going to ask the panel not to conclude my cross-examination of you until you come back to this panel with the facts and the figures to demonstrate this allegation, very, very serious, of you, that in recent years the NPA has not acted against corruption in this country. And by implication, you obviously involve my client in that conspiracy theory of yours.
Chair, I think your client would be in a very good position to give us the information about which corruption cases were prosecuted. But I will go back to the NPA and provide the list of the 85 cases that was outstanding in 2012. I have already asked for that information. I have not obtained it yet, but I think if the request comes from the inquiry, maybe it will give some urgency to the NPA to deal with that issue.
Mr. Hofmeyr, I also want to put it to you, it's quite telling that since 1999 you've been in the NPA. You're the only senior person left standing in that institution, which you now routinely discredit and bring into disrepute, like you did in the spy tapes case. Isn't that significant?
I'm not sure in what sense you're suggesting it is significant.
Because,
But I
let me
have
answer you
had-
quickly.
Sorry?
You
One at a
blame
time.
everyone else other than yourself. That's why I'm saying it's significant. You are this island within the NPA, unaffected by all this sea of corruption around you. And you blame everyone else other than yourself.
Chair, if I was understood to say that, I apologize. But I have no reason to think that what had happened to the corruption cases is the work of more than half a dozen, perhaps a dozen people. I think the bulk of the prosecutors in the NPA do their work well, properly, without fear, favour and prejudice, as they are supposed to. So I'm not sure on what basis Mr. Arends is coming to the conclusions that he made. But obviously those who were in senior management positions relating to the dealing of corruption cases must take some accountability. Ms. Jiba was the head of the NPA. Mr. Mokgoro was the head of the commercial crime courts, where all corruption cases were supposed to be prosecuted. It wasn't always the case in the past. In the past, some of them were prosecuted in the high courts by the DPPs and others. But essentially, for the last few years, all corruption cases were dealt with by the specialized commercial crime courts. So if there's somebody who has to account for what happened to those cases, it's the people who were in charge of those processes.
Who was responsible for the successful prosecution of John Block?
Two very diligent prosecutors in the Northern Cape, plus a police official who put his head on the block to deal with that case. But that case started at the early days of the anti-corruption task team that was set up in 2011-12. And that's the list I'm referring to. Those 86 cases were cases that were being dealt with by the anti-corruption task team. The only one that came to fruition was the John Block case. And I think, to his credit, it was Mr. Similani who essentially allowed that case, and even was very personally invested in making that case happen. Other cases didn't happen, like the issues around the arms deal corruption that the AFU was dealing. We were stopped from doing those cases, particularly about the British aircraft. We had actually gone to court to get a freezing order against Mr. against Mr. Hlongwane at the time for something like 120 million rand in a Swiss bank account. Mr. Similani went to court to have the case withdrawn.
I remember Mr. Arends asked you about the successful prosecution of the John Block case.
I'm giving Mr. Similani the credit for that. He even appeared, I think.
It's okay.
Yeah. So I'm not saying there was zero, but after that one there is pretty much zero.
Mr. Hofmeyr, let's get back to put some focus on you. In the case, in the spy tapes case, the court said on page, it's at paragraph 94, as part of the summing up, it's at small Roman 10. This is what the court said. In the circumstances set out above, Mr. Mshe's stated purpose of preserving the integrity of the NPA and advancing the cause of justice can hardly be said to have been achieved. The opposite is true. Discontinuing a prosecution in respect of which the merits are admittedly good and in respect of which there is heightened public interest because of the breadth and nature of the charges and the person at the center of it who holds the highest public office can hardly redound to the NPA's credit or advance the course of justice or promote the integrity of the NPA. Regrettably, the picture that emerges is one of Mr. Mshe and Mr. Hofmeyr straining to find justification for the termination of the prosecution. Do you still maintain that that is not criticism of your conduct?
Chair, I think I have dealt with this question fairly fully already, but I'm happy to repeat what I said previously if the Chair so requests.
Yes, I think you have. Mr. Arendse?
Yes, we have, and we know that this criticism makes Ms. Jiba's criticism in various judicial pronouncements pale in comparison. Madam Chair, I am moving on to a new topic. I wonder if we could not take the lunch adjournment at this stage and continue at, say, 1:45 or just before 2 o'clock, your time.
I think that is perfect timing, Mr. Arendse. The question is only in the context of us trying to complete this cross-examination of Mr. Hofmeyr, which has been set aside for today. Because tomorrow and the day thereafter, we're going to have to run into difficulties. We would just like to have an idea if we would be able to complete this cross-examination today. We have to. That's what we intended to do. So we'd like to hear from both you and Mr. Mokgwebi's counsel whether we will and of course the evidence leaders whether we can finish this cross-examination and re-examination thereafter today, so that we can determine how long we can set aside for lunch. We might have to come back earlier or not have lunch at all, which is a tall order. We want to finish this cross-examination, yes. Can you get a sense of how it might go on the Mokgwebi side?
Yes, Justice Mokgoro. Without unnecessarily restricting ourselves, we anticipate that it would not be, it will just be a little over an hour. But I'm not, it will obviously depend on how the questioning develops.
Thank you so much. But Mr. Arendse, how long do you think you're still going to be?
Madam Chair, I think I will be at least another 2 hours. I've still got a few other topics to pursue.
Oh, half an hour. And then I guess with the re-examination, it depends what arises out of. Yeah. Can we then do a half an hour lunch?
Yeah, it's likely to be extensive given the number of questions Mr. Hofmeyr has not answered.
Yeah. Can we do a 30-minute? Just gobble up.
I don't know about
lunch,
Mr. Arendse, but we are fine here. I don't know about him. We are fine for 30 minutes.
For 30 minutes?
Yeah, we should be fine.
No, he wants 2 more hours cross-examination. He must try and fit it in. We're trying to assist him, isn't it? Mr. Arendse, you will do with a 30-minute lunch. I hope you're not going out.
Sorry, Madam Chair?
I was saying I hope you're not going out of the High Commissioner's office to have your lunch, because we have just proposed a 30-minute break for lunch, because it looks like we're still going to have a long day.
30 minutes is fine for me. It's too cold to go outside.
Yes, I think keep yourself warm. Wonderful. Mr. Hofmeyr, 30 minutes? Thank you. We will adjourn for 30 minutes and come back at 1:30. Thank you.